Hi friends, today we are going to discuss about regulations and compliance in legal and regulatory aspects. So it's a very basic topic. Everybody know about this, but just to inform you, and there are few aspects that we need to remember in this chapter. The banks are generally regulated by Reserve Bank of India and central government. Now, as the banks are taking up all aspects of business, different business, SEBI and IRDA also have a role because we bankers are selling this insurance products as well as capital market products. We are abide by the SEBI and IRDA regulations also. So these governance generally takes place by BR Act as well as RBI Act. Apart from that, banks need to be registered under Companies Act. If they are cooperative banks, they need to be registered at a state register. If they function within the limits of state, if not, central register. So let us see what is BR Act, what is RBI Act briefly. If there is a need, I will do one more video with wide information. So let us discuss BR Act. BR Act came into existence in 1949. 5B of BR Act defines banking. What is banking? Basically, it is collecting deposits from the people for the purpose of lending as well as investing. That is what banking. So everybody can't do banking, only few people can do banking, those are bankers. Yes, there are private organizations that can collect the deposits. There are separate regulations for those. Okay, leave it. So 5B defines what is banking. Then comes 5C. It defines banking company. Banking company is the one which do banking. So all companies can't do banking. Banking companies can't do all other activities. So banking company, that is the one that can do only banking. So what they can do is defined in section 6.1. So in this, permitted and prohibited business is defined. So we don't need to behead all the 11-20 points of permitted business. Whatever we are doing right now is permitted business. What is prohibited is generally whatever banks nowadays not doing, because banks are doing everything under their definition. They are they are more insurance companies than banks, to be frankly. So what is prohibited business? Basically, trading activities, stocking activities are prohibited business. We can't keep stocks of goods or any other thing. We can't participate in trading. So these activities are prohibited. Then under section 22, license will be issued by RBI. RBI issues license using BR Act as well as RBI Act. And section 49A gives cash withdrawal by check. It seems to be silly, but it is very important, this 49A, because only banks have the right to allow the withdrawal of deposits by check. This banking companies can't issue checks. Only banks have right to issue checks. Why checks are so important? In case of checks, they are almost equal to money. Like only RBI is authorized to give legal tenders. So as checks are almost equal to money, they got the power of issuing legal tenders almost, but it is not available to any other organization. Bitcoin is there, like cryptocurrency. Bitcoin is there, but they are not authorized by government or any other regulatory bodies. Worldwide, they are not organized. They are also equal to money. So only banks have that right. That is 49A. Section 49A gives cash withdrawal by check. Next comes RBI Act. RBI Act came into existence in 1934. As of this, only RBI came into existence. Before that, Imperial Bank of India is there. Later, that RBI came out of Imperial Bank. Then that Imperial Bank, after freedom, became State Bank of India. Everybody knows this story. So S3, Section 3 constituted Reserve Bank of India. Section 20 makes RBI as banker to central government. Particularly, the goal of RBI is securing monetary stability and regulating printing of notes. So, this section 22 gives printing legal tender. That means gives rights to print legal tender, that is currency notes. They can print legal tender from 2 rupees to 10,000 in consultation with central government. So RBI have one governor, 4 deputy governors. It works based on independent board of directors decision, but it always go in consultation with government, because government, it have to follow government directions in public interest. It have branches at Mumbai, Kolkata, Delhi and Chennai, 3 cities in North India, 1 major city in South India. So 4 cities. And then 7.1 gives government right to government for intervention. 13D gives right to winding up to RBI. That means RBI can wind up the banks under 13D. Section 18 gives rights regarding they can direct discount of bills. It is not so important. Section 42 define cash reserves. Here, while preparing for bank exams, we are very familiar. We used to byhead those reserves. All those reserves need to be followed by the banks because of this section 42. Then comes cooperative banks. Not so important, but a basic understanding is required. Primary, district, state, all these cooperative banks, that means which are functioning within the borders of a state, have to abide by the law of State Cooperative Society Act of that state. If any cooperative organization working in more than one state, then they have to abide by the Multi-State Cooperative Society Act 2002. This we need to remember. And with the amendment of section 56, it happened in 1965. With that amendment, RBI amendment, these cooperative banks, along with within the they are already within the control of states or central according to their function. Along with that, RBI also governs them. And if these cooperative banks are registered under Deposit Insurance and Credit Guarantee Corporation Act, then RBI has power to winding up those ones also.